Good evening, everyone. Welcome to the second webinar organized by Law Laboratory in association with LawPanch and burnished Law Journal. I'm Niti Kumari, and it's my honor to be one of the moderators for the session on the topic Reforms in IBC post-COVID-19. Our guest will speak on this topic today, and then there will be a question answer round, and for that, audience can use comment box. So without further delay, I will briefly introduce to you all our guest speaker, Mr. Arpit Maheswari. He is a practicing Supreme Court lawyer and partner at Arcs Juries Advocate and Consultant.
Thank you, Nidhi. I, Mukund Maheshwari, on the behalf of all the organizers and audience, welcome Arpit sir and request him to take over the mic. We look forward to have a healthy discussion on the topic. Sir.
Sure, absolutely. So it is my pleasure to enlighten you on the point on this topic, and I'll try my level best to clear all the doubts and if any questions that you have.
Sir, as we know, recently the government has passed an ordinance to amend the IBC, by which no fresh insolvency will be initiated against the companies impacted by the outbreak for the 6 months. So we think that it will extend to a year. So can you tell us more about the ordinance and the silent feature of this ordinance, sir?
Okay. So, in fact, recently our Prime Minister Ramnath Kovind has approved of this ordinance. And so this ordinance basically talks about and was passed with the intention to curb out the effect of COVID-19 on the struggling businesses which are there. So basically, the object of this ordinance is to since there was very much of uncertainty and stress on the businesses for reason beyond anybody's control, and of course, added to that effect is the national lockdown which has happened. So the parliament, so the constitution makers, so the lawmakers of India has come up with this ordinance, and through which they have inserted an amendment in the Insolvency and Bankruptcy Code, by which they have suspended Section 7, 9, and 10 of the Insolvency Bankruptcy Code. Now here, Section 7, 9, and 10, let me explain it to you what they say. Section 7, 9, and 10, yeah. So Section 7, it talks about how a financial creditor can initiate insolvency proceedings against a person, against an individual or a company. Section 9 talks about how an insolvency insolvency plea can be initiated through an operational creditor. And Section 10 talks about how insolvency can be initiated by the corporate debtor. So these are the major, and these are the backbone of this statute. The salient and the other, you were asking salient features of the ordinance, right? So
Yes.
These are the salient features of the ordinance, and as you rightly said, now this ordinance is effected from 25th March 2020. And extended for 6 months, which may extend till 1 year, as the case may be, and as per the convenience of the government, as the government decides.
Sir, in your opinion, what are the benefits that a debtor company can reap out of this ordinance? And like, what are the practical challenges that a creditor as well as the debtors will face because of this amendment?
Okay. So I'll address your first question, sir, that what are the benefits that a debtor company can reap out of this ordinance?
Yes, sir.
So first of all, what we should understand is how this ordinance is going to benefit the companies which are already under stress, right? So by this, the government aim to give them a moratorium or to extend their time for moratorium for 6 months, so that no insolvency can be initiated against those companies which are already under stress, right?
Okay.
And as I've said earlier, this stress is because of the reasons beyond anybody's control, and of course plus the lockdown that has already imposed. So the objective is to, first of all, we need to address this point, that the objective is uh, to give some kind of relief to those companies. So this could be one of the benefit that the debtor company can reap out of this ordinance. The other thing could be is that now the companies don't have to don't have to sell their assets, their all the sell their assets, their bonds, to raise money for the debts and to clear all those debts, right? So this ordinance, this law will be a welcome move for those companies. The other thing
Okay.
which could how this ordinance will benefit these companies, stress companies, is that now the companies will can explore alternate avenues, if not insolvency. Let's say
Okay.
if a creditor wants to take money, wants to recover money from a debtor, they can choose certain other alternatives with less harsher than the IBC proceedings. Because
Okay.
obviously once the IBC proceedings are initiated, the court take cognizance over the application, they appoint a IRP, and then everything, the management and everything goes out of the hands of the company's directors. Now what can happen is that companies, both creditors and debtors, can look for other alternatives like mergers, like amalgamations,
Hmm.
like acquisitions.
Right.
So this can be done. So this will prevent those companies from those creditors to hostile takeovers and leverage buyouts of those debtor companies. So this ordinance can be very helpful for those who actually look forward to continue their businesses and are a bona fide businessmen and a bona fide debtors, and of course want to want to return clear of their debts in any manner whatsoever. This can be a welcome move for those.
Sir, can arbitration be a way of recovering money from the debtors?
Absolutely. So in fact, uh, now every business, every company every company who has a agreement with another company for anything, any for a very small as an employee agreement, to a vendor agreement, to a anything, right? So all of these clause has an arbitration clause. All of these agreements has an arbitration clause. So of course the companies can explore alternate mode of litigation through arbitration. And of course there can be several other uh, mode of litigation through which a creditor can recover money, and that could be a simple civil litigation, I would say. That could be a very another type of litigation, a company petition. That could be a company petition. So there can be an alternate ways of recovering those debts. But then again, since I have said earlier, IBC is a very harsher law, and the main aim and objective of the parliamentarians was to give relief to those companies who are distressed, and who intend to pay off their debts. But then so I think this is the reason for the for this amendment in IBC. And as you
Right.
say, the other coming to the other question, that practical challenges that the creditors and the debtors will face is, of course there can be practical challenges. All the benefits that are given to a debtor company is actually a challenge for a creditor company. So that could be one. The
Yes.
other challenge that can be faced by a creditor, by a debtor, I'm sorry, by a creditor, yes, is that all those operational creditors, including employees, including vendors, including MSME companies which are exclusively dependent upon certain companies which has exclusive agreement with the debtor company. They will affect the most. They will affect the most because again, employee, they are getting their earnings from the company. If the company, the debtor company, stop paying them, they don't have, they'll not have money to run their families. Vendors in
Yes.
a way will obviously get affected because eventually when a company is not paying their vendors, how will they do businesses? Because obviously a vendor has several arms of doing businesses. So once a debtor is not able to pay their vendors, how will they do businesses? And again, MSME companies, which this government intend to give benefit the most. I think this moratorium for 6 months is going to affect them a lot, in a way that obviously the money which is blocked, which is blocked, they will not be able to recover it through insolvency bankruptcy court. They will again have to approach through different means, if at all they want to recover their money sooner or later. So alternate modes, again, civil litigation, arbitration, other things that can be done.
Sir,
So,
can you?
can you
Yes.
explain in detail these modes to recover the money?
Sure. So, as I said, this can be recovered through arbitration. See, since arbitration is not suspended by any government, arbitration could be a mode wherein a creditor company can invoke an arbitration clause and ask the debtor company to pay off their debts, appoint an arbitrator as per the act, and can go ahead with the arbitration proceedings. The other thing that can be done is through recovery suits. But then again, recovery suits will cost them a lot of money as comparison to IBC, because for recovery suits, they will have to pay ad valorem court fee, which will be too much. And in insolvency bankruptcy court, there's a fixed amount of court fee, so that won't be much. But so then again, this could be another challenge. Recovery plus recovery suits are very slow. It
Yes.
takes time. It takes a lot of time. Once the litigation starts, it takes a lot of time to actually realize the money. But then again, since the act says this, since the amendment says that the act, this certain sections will be suspended for 6 months. So what we can do is, uh, at the same time, after initiating a recovery suit, we can also, of course, initiate an IBC proceedings after the expiry of 6 months, so that the company who's actually under debt, the creditor company can initiate insolvency proceedings against the debtor company. And the company can take over their disputes from there before the National Company Law Tribunal. So that can be done.
Right, sir. Right. Sir, recently we came to know that there are some like laws which the government is making them like decriminalizing them, like for say check bounce cases. So, what are your comments on that?
Okay, so you see, check bounce case uh, is already a full-fledged legal system which we are following. It's
Yes.
a complete act in itself, and it's a very effective act, I must say. And decriminalizing it would, I think, would going is going to affect the entire financial system, entire unorganized, I would rather say, the unorganized creditors debtor system, the unorganized system, which is the system which is not governed by RBI. So that financial system will affect the most,
Okay.
because once because decriminalizing negotiable instrument, check bounce and negotiable instrument act, provisions of negotiable instrument act, is going to affect the market, I think, market at large.
Right.
Yes, sir.
Yes, sir.
Yes.
Sir, how can this suspension be an opportunity for the companies to restructure themselves by the way of mergers and amalgamations without worrying about the hostile takeovers and buyouts?
Okay, so again, since the debtors will not be at the mercy of the creditors, because earlier when the IBC was there, section 7, 9 and 10 was active. uh, what what creditors used to do is that if the debtor is not paying their debt, they'll start straight away initiate these proceedings under IBC by way of these sections. Now, since these sections are suspended for 6 months, now the debtors will have a level playing field with the creditors to negotiate their deals, to negotiate those mergers and amalgamations and acquisitions with the creditor itself. So, in this way,
Right.
debtor will not lose their administrative power over the management, and of course at the same time debtor and the creditor will have a healthy relationship, right? So mergers and acquisitions uh, is a great alternative, especially in this period when when the provisions of IBC is suspended for 6 months. So again, uh, so when the debtors will have a level playing field with the creditors, there will be a less chance for a hostile takeover and a leverage buyout by a creditor. So
Yes.
this could be a very good opportunity for the debtors to act at par with the creditors. And I think the other thing which is important here is to see that the provisions of Companies Act, as far as section 230, 231, and 232 is concerned, which talks about mergers, acquisition, amalgamations, is very lenient, and is very lenient in comparison to IBC provisions. In these provisions, their courts generally don't get themselves too much involved with the restructuring and with the kind of takeover and merger which is going on, unless and until which is absolutely against the law. uh, uh, Courts generally don't indulge themselves into getting into the nitty-gritties of the merger and amalgamation. So that could be a very good thing. And I think the other benefit that a company, that a debtor can get from this is that in company law, decisions are taken by the creditors and creditors and members and shareholders, right? On the
Hmm.
contrary, in IBC, committee of creditors takes all the decisions. The decision
Okay.
making power lies in the hands of committee of creditors once the insolvency is initiated. By the way, so
Hmm.
this again could be very healthy for the debtors, because all the because once this is accepted, once the merger or amalgamation is confirmed between two companies, and is accepted by NCLT, so the companies can move accordingly in a manner which is predetermined and described, predefined between the companies, between the creditors and the debtors.
Sir,
So, any other comment or suggestion would you like to give on this topic?
Uh, yeah, you know, I think there are two, three things that could go against the instinct of this amendment. First of all, what I feel is that government should not give a blanket order. You should not pass such blanket order, where they uh, suspend statutes which is of this great importance, because you see, the object of insolvency bankruptcy code is of ease of doing business, to promote ease of doing business. And by suspending these sections, the government has virtually uh, gone against the objective which was which was there to enact this statute at the first place.
yes.
So I think this should not be a blanket order.
Like
Uh,
it depends on, like it should depend on case to case.
Yes,
Absolutely,
yes.
it should be voluntarily. If a
Mm-hmm.
person, if a debtor wants to exercise this suspension, the exercise the benefit out of this order, he should be most welcome to do it. He should be welcome to do it. And at the same time, if the creditor wants to take, wants to suspend, doesn't want to take enact section 9, section 7, 9 and 10, he should be welcome to do it. But imposing a blanket order is actually creating a balloon in a in the in a industry. And the other thing that could be, that could be uh, against the instinct of the act is that uh, companies who wants to voluntarily initiate insolvency cannot initiate now cannot initiate insolvency. Right. So the balance sheet of those companies, which is already under debt and under stress, now wants to initiate insolvency, cannot do it. So the balance sheet is deteriorating. So this act is affecting the balance sheets of the company. Then, of course, when the balance sheet is initiated, the value of the company over and above is affected. So
Right.
eventually, this will affect the company and the management of the company and the shareholders of the company. So once, let's say, if the company is not able to voluntarily initiate insolvency now and have to initiate it after 6 months, and let's say if the company value of the company will reduce to 25%, it is a loss to shareholders and the company. So I think at least government should open this window of initiating voluntary insolvency of the companies who wants to initiate it by themselves.
Right, right, right. This can be an
Yes,
alternative
sir.
also.
Absolutely, this can be a very good alternative.
Yes. And sir, like in comparison to other countries, what could be done better in India regarding this? Regarding like here we has like suspended directly the three sections of IBC.
Hmm.
How, like in comparison to other countries, what better thing could be done other than suspending these three sections?
Okay. Uh, so what I feel that instead, see, again, suspending these sections is a welcome move for those who are genuinely under distress, right? And who are genuinely and who are the who are bona fide businessmen and wants to do and wants to actually create something for themselves, right? And wants to
Yes.
clear off their debts, but not for those who will misuse these provisions of the amendment, right? So
Hmm.
to so coming back to your question, that what other things that a country, that our government can do, what the other countries are doing, uh, is that government should send direct aid. That's what I think. Direct aid to the companies who are in distress, and not in the form of loan, but in the form of as a credit, but not I mean, and that should be left on the companies and the debtors to realize. I mean, that should be left upon the debtors, that as and when they can return it, they may return it. So instead of
Okay.
suspending it, I think government should give direct benefits to these
Then,
distressed companies.
Right, right, right. Okay.
yes.
So yeah, that's what I feel.
Thank you, sir, for interesting discussion. Now we'll be having question answer round, and for that, the audience can use comment box to write their doubts and question.
Okay, sir. So we have a question from Mr. Avinash. So he's asking, what if the company wants to, company wants an alteration in the article of associations of its company? Can we do so after the after this pandemic COVID-19 thing?
See, article of association of company is governed by Companies Act, and no provision of Companies Act is suspended during this course of lockdown and post this pandemic, and of course the unlock which has started now. So
Yes.
article of association of a company can be amended at any given point of time, And but the only requirement is that you have to inform the registrar of the companies before the amendment, and of course these amendments, these changes should be produced before in a special meeting before the creditors of the company to get it approved. Creditors and members of the company, as the case may be. I'm sorry,
So,
not creditors, shareholders. I'm sorry.
okay.
I've been talking about
Yes,
this
sir.
IBC and creditors, and I've been
Yes.
using these terms creditors and debtors, so it come out accidentally. But yeah, shareholders and the members of the company.
Members.
So I think this is the last explanation, last doubt of this session.
Okay.
So I would like to extend my hearty vote of thanks to our honorable guest, Mr. Arpit Maheshwari sir, and all the attendees who joined us today. And yeah,
So I, on behalf of all the organizers and all the fraternity present here today, will extend heartily thanks to Mr. Arpit Maheshwari, who has spared his time from his busy schedule to give this evening. Thank you, sir.
we all are inspired by your great words, sir, and it will be very helpful to many of us to understand this topic in detail. Thank you so much. Have a good day.
Thank you
Thank
so
I
much.
hope I've been helpful to you. It
you.
was like nice
Thank you.
talking to you both, to both of you.
Okay,
Thank you,
sir.
sir.
Thank you so much.
Thank you
Okay.
so much.
Okay.
Have
Have a
a
good
good time, sir.